The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina has resumed sitting for the dispatch of business. God save the state and this honorable court.
Good morning. Welcome to your Supreme Court. The court calls 458A19-1, N-Ray, WK, and NK. Ms. Joyce?
Good morning. May it please the
morning.
court, I'm Kathleen Joyce, and I represent the appellant, the respondent father, Kevin J., whose parental rights to his children, Natasha and Wesley, were terminated in orders entered in September 2019. Two people appeared with Kevin at the start of his TPR hearing. One was his court-appointed attorney. The other was his Rule 17 GAL. The latter was appointed based on the trial court's determination that Kevin had been diagnosed with, among other things, schizophrenia and bipolar disorder, had an IQ of 71, and received disability benefits through an alternate payee. Whether a trial court abused its discretion by failing to appoint a Rule 17 GAL in a TPR matter is the most common appellate issue raised by 7B 1101.1, the statute that provides for appointment of a parent GAL. That issue is not before us today. Here, the trial court made the proper inquiry into Kevin's competence and exercised its discretion to appoint a Rule 17 guardian. But the facts of this case raise a new question. What comes next? Once a Rule 17 GAL is appointed, does a trial court have a continuing duty to ensure that the guardian plays a meaningful role?
Ms. Joyce, can you speak up a little bit? I'm having a little trouble hearing you.
Sure, I'll try.
Thank you.
If I can get closer to my... Our answer is an emphatic yes. Is that better? Yeah. Our answer is an emphatic yes. Here, the guardian was present in court, but silent during a hearing at which Kevin failed to appear, and his attorney consequently was unable to present any evidence. Rule 17 provides that after the guardian has fulfilled his statutory duty, the court may proceed to final judgment. In the face of the guardian's silence and the respondent's absence, the court here had a duty to make some inquiry into what the guardian had done to fulfill his role as the guardian of due process for Kevin, and to explain what he had done to explain and assist Kevin in executing his rights. The court's failure to do so undermines the fundamental fairness of the proceeding and requires that the termination orders be vacated. Our legislature has determined that one of the requirements of due process is the opportunity for parents facing termination of their rights to be heard through their meaningful participation in the proceedings. When, as in this case, a parent's mental illness and cognitive impairment prevents meaningful participation, the legislature provides for appointment of a guardian to ensure that the parent's due process rights are protected. There's nothing to suggest that this is a pro forma provision. In fact, the statute has been amended several times to provide greater clarity on the scope of the guardian's role. The decisions of both this court and the Court of Appeals have confirmed that the guardian is intended to have a meaningful role.
Do you think that the guardian is to be a second attorney for the individual, or is the guardian's primary role in a situation where there is an attorney already to ensure that there is proper communication, but also that the attorney is providing the representation under all circumstances?
Yeah, Justice Newby, I think that the latter perfectly describes what the role needs to be. There's no indication in the current statute that there was an intention to provide, a second chair. That the Rule 17 guardian doesn't even need to be an attorney. It happens that it is in our system, but you know, the role is that of really standing in the shoes of the respondent in the areas where he can't, in this case, you know, function for himself. It's a limited role. It's not doesn't apply to the rest of his life. It applies to this case, and it's going to vary depending on, you know, the nature of the incapacity or the lack of capability.
And let's talk about that a second, at least from my, you know, past experiences with guardian ad litems appointed pursuant to Rule 17. And it seems to be the case that those principles apply under the current version of the relevant statute here. You essentially get a guardian ad litem when you are incompetent, which means that, at least as I understand it, that you are not able, because of limitations under which you suffer, to make the decisions that a person not subject to those disabilities would normally make in the absence of except for the disabilities. Is that right?
That's absolutely correct. You know, the Rule 17 uses the Chapter 35A definition of incompetence. It does not require a full-scale inquiry into incompetence as it would if you were appointing a guardian to represent the ward in every aspect of.
So the purpose of the guardian is to have someone present who is not subject to disabilities available to make decisions that would ordinarily be made by the respondent?
Yes. For example, and I think this case it illustrates why it is useful and necessary to have a Rule 17 guardian. You know, when you think about the things that a competent respondent would be able to do in assisting his attorney or exercising his rights, you know, the discussion about whether to have the attorney withdraw, whether there should be whether he agrees to a continuance, whether when Mr. Joyner didn't appear at the second hearing, you know, the role of the guardian had to be even more pronounced.
Which would be in essence to give instruction to the counsel.
Exactly. Yeah, it's not to serve as secondary counsel. And, you know, I think that's where the analogy to ineffective assistance of counsel, that's one area where that analogy falls short.
Well, and I guess that's my ultimate concern here. If the purpose of the requirement of the guardian is to ensure that someone competent is present to make decisions that we would ordinarily have made by the litigant themselves, and given that we typically don't let somebody appear both pro se and through counsel, how relevant is it that the guardian ad litem actually spoke up during the hearing?
Well, I think, you know, absolutely we don't. The statute doesn't envision a situation where, you know, as with the juvenile GAL, they're a party and get, you know, a separate chance to cross-examine and present evidence. So, you know, the Rule 17 guardian is standing in the shoes of its ward and only doing the things that would be envisioned in the normal proceeding where the respondent was fully competent.
Is in the event that the Rule 17 guardian sees nothing untoward being done by the counsel, does the Rule 17 guardian have any obligation to do anything other than sit there and watch?
Well, there is, that's why we have to be careful about the silence. You're absolutely right that just as the respondent wouldn't appear on the record as making an objection or saying anything, the Rule 17 guardian wouldn't as well. However, when, that's why it's important to look at the specific examples in this case of where the court could have made inquiry of the guardian and did not. I mean, the court started.
Okay, well, let's look, for example, one of the things that you pointed out in your brief is the statement made by what was done by the guardian at the time that there was a question of whether the attorney should be allowed to withdraw or not.
Mhm.
It seems to me that if the guardian was satisfied with the way that the attorney was proceeding, even if the litigant wasn't, what obligation does the guardian ad litem have to help the litigant do something that, in the guardian's opinion, might be harmful to the litigant?
Right. Well, I mean, I think there's a separate question about, clearly defining the, the interest represented by the guardian. But I think apart from that, your example is a good one. That's where the system functioned well in that instance. The court stopped itself and said, wait a minute, I already gave you a Rule 17 GAL. I have, my order shows that I've determined that you are not competent to be making your own decisions in this case. And so I can't let you waive counsel, and I need to check in with the guardian. And, as you suggested, there are many good reasons why the guardian would say what he did, which is, I have nothing to say here because he doesn't want to alienate the client, but he also doesn't want to, do something that is destructive, as in forcing the withdrawal of the attorney. So that was perfect. We needed to see more of that throughout the hearing, and we didn't.
Well, exactly. Tell me, I know you've got it in your brief, but I at least had understood you to not be exactly content with the way the guardian ad litem handled the situation with the attorney. I appear to have been wrong about that. What is the guardian supposed to have done that doesn't duplicate what an attorney would ordinarily be responsible for that wasn't done in this case?
So I want to make sure that I understand. As I said, in the first instance, I think that the system worked well, that the judge realized that because there was a GAL, she needed to be talking to the GAL and to see whether the GAL had anything to contribute on the issue of the attorney withdrawal. Once that issue was disposed of, then there were more opportunities for the judge to do that kind of check-in that didn't take place. And those all.
So, all right, I'm sorry to interrupt you, Ms. Joyce, but so is your argument then that the trial court did not periodically intervene to ensure that the Rule 17 guardian was doing or not doing things that you're supposed to do?
Well, there are two answers to that. First is in this case, there were very specific points when it would have been appropriate for the court to inquire of the guardian. For instance, when the second hearing began and the respondent did not show up, then that would have been, the history of this case is important too, because the Rule 17 is a flexible rule. It does not give, we don't have detailed requirements of what a GAL has to do. It's going to depend on the capabilities and the corresponding, incapabilities of a particular litigant. And so in this case, the history of the case is really instructive. There had been a prior appeal because Kevin did not show up at his hearing. Kevin showed up at his hearing, said, I want to get rid of my lawyer. The judge sent them out into the hallway to discuss what to do. He had not waived counsel. Nothing was brought to a conclusion. And according to the attorney, when they went outside to discuss this, Kevin was saying, well, I need to take advantage of my ride. And so he prioritized getting a ride home over being present in court and dealing with the issue of who was going to represent him. So that was reversed because the court proceeded without an attorney and without Kevin present. So knowing that history and knowing the evidence that the court looked at when it made the decision to appoint a guardian, we know that Kevin has difficulty processing information that's related to his low IQ. The court in its findings said, he has poor judgment and poor insight. So this is a person who prioritizes, getting a ride home over being in court to attend to his termination of parental rights hearing.
Well, Ms. Joyce, do you contend that your client was tangibly prejudiced in any way by the actions or inactions of the guardian? And if so, how?
Well, I would say that it's not a matter of prejudice, because it's for one thing, it's too hard and a silent record to know. But I also think because I think we need to stay away from any kind of IAC showing a requirement of prejudice, because the role of the guardian varies so much. There's no clear standard of what a guardian should do. And that's why I think the focus has to be on what the trial court's role is, and not on what the guardian on the guardian's actions, as much as at these critical stages, did the trial court do what was necessary to ensure that the guardian it appointed to safeguard the due process rights in this case was having that effect.
If I may follow up on that question, do I understand then essentially what you're saying is that the standard of review that we're applying here is not analogous to an ineffective assistance of counsel claim, where we would first determine whether there was ineffective assistance and then determine whether there was prejudice, but instead the appropriate standard is abuse of discretion on the part of the trial court, and that's what we have to assess, whether the trial court management of the GAL here was an abuse of discretion?
Yeah, so I would definitely say that we are not looking at a Strickland standard of review in terms of ineffective assistance, because the inquiry is not about the errors of the GAL, it's about the errors of the trial court. And I would love to have a different standard of review than abuse of discretion.
Well, let me just stop you there. Normally, we think of abuse of discretion in reviewing a trial court's ruling. It seems a little strange to me to apply an abuse of discretion standard to the inaction by a trial court, but it sounds like that's what you're arguing.
Well, maybe by default I am. This was a discretionary decision of the trial court to appoint the GAL. And then, there is a duty once that, so there's a duty to inquire. And then, so the court fulfilled that duty and exercised its discretion to appoint the GAL. But it's unclear how, again, what, other than the court has a duty, is responsible for the administration of justice in the courtroom, and has a role in ensuring that we have a fair proceeding. And I mean, those are pretty big requirements. So I would say, as part of that, we're looking at, did the court do what it needed to do? And I would love to argue for a de novo review of this, and I certainly wouldn't Um,
Can I ask you something specific about the judges, what the judge should or should not have done? At particular points, there was, for example, one place where in August of 2019, the father did not appear, the GAL was present, the GAL didn't say anything or object to the second day of the hearing, and the judge didn't ask him anything. And is that one of the points where it's your argument that the judge should have done something? And if so, what?
Yeah, exactly. I think that that's where it all starts. That at that point, knowing that Kevin has a history of not uh, re, uh, of having difficulty doing what he needs to do, of making good decisions about going to court, that that would be a time when it would have an obvious place for the court to say, I see that the respondent isn't here. You know, guardian, do you have anything to say about that? Now, the guardian has confidentiality requirements as well. And so, you know, what he would say at that moment varies, but but it is a time for the court to make its own inquiry to say, to find out, have you done anything to assist this litigant in exercising his due process rights?
Well, if the attorney, to use the example that you were discussing with Justice Hudson, if the attorney is making an adequate argument in favor of a continuance, what purpose would be served by reversing the case because the guardian ad litem also didn't speak up on the record? Again, if the purpose of the guardian ad litem is to make sure that the attorney is doing his or her job, why is the trial court required to do something beyond allow the attorney to represent his or her client?
Well, I think one thing we have to consider is why would we even have a guardian if there wasn't a meaningful role for the guardian to play? You know, as I said, this is not, this is not a checklist for due process. As long as I've appointed the guardian, that's taken care of. There's got to be some teeth to this.
Except that generally the rule is, and I'm speaking very, very broadly, generally speaking, the rule is that trial judges are presumed to have followed the law in the absence of showing to the contrary. Your argument seems to be that in this instance, unless the trial court periodically makes inquiry of the guardian ad litem, in addition to allowing the counsel to speak, there's been an abuse of discretion and a new termination hearing is required. Am I mischaracterizing your argument when I describe it that way?
Well, I would not say that you're mischaracterizing.
Well, I mean, it's perfect. I mean, I'm asking you that to make sure that I'm not.
Yeah,
I mean,
I would like to refine
if
that.
you think that I am mischaracterizing it, I need you to tell me.
Okay. Well, what I would say that is different about the argument that I'm making is not that let's go by the clock and every 20 minutes the court makes an inquiry, is things okay there with the guardian, but that there are critical stages, and one of them is making a decision about asking your attorney to withdraw. And then potentially having to decide about whether to appear pro se. That's a critical stage, and the court needs to make that inquiry. And it's an inquiry that the court would make of the respondent, but because there's a guardian, then the court needs to make it of the guardian. So
well,
if the
guardian ad litem is, as I'm following what you said earlier in your presentation, standing in the position of his or her ward, and there is an attorney present, then if you just do the direct substitution, the trial court would not be asking the respondent directly, with the attorney being there to represent his or her interests. What matters, it seems like you're saying the guardian ad litem should be asked by the trial court periodically How would that mesh with what the attorney's role is, especially in light of 1101.1D, wherein the guardian ad litem is not expected to act as the attorney for the respondent?
Well, thank you. There are a couple things there. One is that the roles are very distinct, and but there's a provision for two roles. So there has to be some function that the guardian is intended to serve. One of them, one function would be to is to stand in the shoes and be able to have the capability to assist the attorney in all the ways that a litigant would be able to do that. In this case, there's a heightened, when we think about the due process protections, that when someone is incompetent, when a litigant is incompetent, then there's a heightened need for extra provisions. And so that's where it kind of falls down, that it's precisely stepping in the shoes. It's a little bit more because of the vulnerable state of the respondent. So that when the respondent doesn't show up at the court for the hearing, then it's reasonable for the court to make that inquiry directly of the guardian. When the attorney was not able to present evidence at an adjudication and disposition and says, I can't do it because my client's not here, then that would have been a time for the court to say, guardian, do you have anything do you wish to be heard? It could be as brief as that. So getting back to Justice Urban's question, it's not periodic. It's when an issue arises. So it could be in a different setting, that second hearing, if the client had been there and there'd been no issue about being able to present evidence, then silence would have been appropriate.
Well, these are things that could have happened, but because they did not happen due to inaction by the trial court, does that rise to a level of error on the trial court, as the trial court did not see fit to do that because the attorney was there to represent the interests legally of the respondent father, and the guardian ad litem was there in the event that something came about wherein the guardian ad litem had to stand in the position of the individual and therefore protect the interests of the father in the father's absence?
Right. Well, and I think these things did happen here, whereas the father wasn't there and the court did not make those inquiries. And so in another case, there might be a different requirements for what the court would do. There might be no inquiry throughout the hearing because there's no reason to question whether that protection that was intended to be offered by the guardian ad litem was in fact offered. And I realize that I'm almost out of time. I just did want to point out that there are ways that a court could proactively deal with this. That there is a provision for a pretrial hearing where they go through a checklist of was this done, was this done, was this done. That could be an opportunity for the court to say, okay, I appointed a GAL. Let's make sure that you know each other and that something has happened. So there are. And that's something that could have been said at the outset before anything else, before they got into the hearing, just to check and make sure. So there are ways that we can do this without it being disruptive, without it interfering with the attorney-client relationship. But the fact of the matter is that the General Assembly saw fit to create this role and carve out a place for it in the juvenile code, and that's. We have to make sure that the courts are giving that meaning. And I'll reserve the rest of my time.
Thank you. I understand that Mr. Young and Ms. Kelly will divide their time.
That is correct. Your Honor.
Mr. Young.
May it please the court, it's both a pleasure and a very humbling experience to argue in front of you this morning. I had the privilege of being trial counsel in this particular matter. I'll be representing the Iredell County Department of Social Services in this particular case as the appellee. The case itself started June 15th, 2019. At that point, Mr. Joyner was appointed as his Rule 17 guardian. The hearing itself began July 25th, 2019, was continued to August 15th, 2019. Present were Ms. Brotherton, who represented Mr. Joyner, Mr. Hedrick, who was the Rule 17 guardian, Ms. Kelly, and myself. The issues that have been raised in this particular case by the respondent father relate to two essential claims. The first is that there was a lack of active participation, which we've been discussing, or which has been the subject of discussion, and an insufficient factual basis. Your Honor, with regard to the second issue, I would simply note that the respondent father only objected to 4 of the findings, leaving 35 findings of fact intact. Those findings are binding on any appellate court, and I would submit that those are more than adequate to substantiate that neglect and failure to make reasonable progress occurred. With regard to the issue of lack of active participation, there are 3 essential elements that I would suggest lead to the conclusion that there was, in fact, active participation. That's the facts of the case, the law in this case, and then common practice in the state of North Carolina and the trial court level. With regard to the facts of this case, I would respectfully disagree that Mr. Hedrick was active in this particular case. He was active both before court, he was active during court, and he was also active after the fact. With regard to the how we know this, we know it because of the transcript, we know it because of the record. The transcript reveals that Mr. Hedrick and Ms. Brotherton met with Mr. Joyner before the hearing. The billing records substantiate that there was about an hour and a quarter meeting prior to. Mr. Joyner acknowledges that he had that in the transcript. He had a meeting. He had trouble recognizing or remembering Mr. Hedrick's name, but he nonetheless did acknowledge that he had a meeting with him. During the course of the proceeding, it's certainly the case that Mr. Hedrick refrained from making active comment in the second day, that August 15th day, but he was joining in objections with the respondent father's counsel, and was responding to inquiries from the court throughout the entire proceeding. After the proceeding was concluded, after the order was entered, the guardian assisted in the perfection of the appeal. So I would not characterize Mr. Hedrick's behavior as being silent or inactive, but rather participatory and doing those things that are commensurate with the role of a guardian. Now, how do we know that he was doing what he was supposed to be doing? That's where I think the law in this particular case comes in. The respondent father's counsel relies heavily on the case of Henry ASY, and I think for good reason, because as counsel has acknowledged, it sets forth some very important points. In that particular case, as far as the factual setting is concerned, that was a case in which the guardian ad litem had withdrawn. It's not the case here, but it does set forth the requirement of an active participation. But more importantly, it sets forth this requirement that there be flexibility. And I believe counsel agreed that there's a flexible standard. When the facts on the ground require it, there's a need for more or less participation. I know that Mr. Joyner was not there, but the reality of the matter is the facts on the ground, those facts observed by Judge Underwood, were that the respondent the respondent counsel was actively objecting. She was objecting all over the place. In fact, over almost a dozen times throughout the hearing. So Mr. Hedrick was right to observe that things were going on in such a way that Mr. Joyner's due process rights were effectively preserved and championed. So to the extent that he had that opportunity to observe that, to the extent that he had the opportunity to make a determination, what do I need to do? He could rightfully have deferred to the actions of counsel. So
do you equate flexible standard with a case-by-case basis analysis?
I believe that that's appropriate. I don't think it's appropriate to set a one-size-fits-all standard in these cases, because it would hamstring any appointed guardian into doing things just because they're covering themselves from liability, I suppose. Each case is different. Each case requires a different standard and a different approach.
Well, in your experience practicing in the trial courts, what do you believe the differing roles of the counsel for the parent and the guardian ad litem for the parent under Rule 17 are and ought to be?
Justice, I believe in my experience, the role of a Rule 17 guardian is a lot of that role is counseling the client before the trial begins. A lot of times the individuals who are appointed the Rule 17 guardian exhibit behaviors which are problematic for purposes of trial. So counseling, speaking with them actively is appropriate before the trial. That's, I think, where a lot of the work and the heavy lifting takes place with a Rule 17 guardian. But once that trial begins, I think that the proper role for a Rule 17 guardian to let trial counsel lead the way. Trial counsel has an obligation to take the objective of the litigation, certainly, but once that objective has been set, it's the trial counsel's obligation to set a path and set a strategy, and the Rule 17 guardian is to cooperate with that strategy.
If I'm understanding Ms. Joyce's argument, it seems to me her concern essentially is that there be a mechanism by which the trial court makes sure that the Rule 17 guardian is actually doing what he or she is supposed to do. I mean, I think that's ultimately where her concern lies. What mechanism exists, as you see it, to make sure that the Rule 17 guardian does, in fact, do what he or she is supposed to?
Justice, I think that the answer to that question is what happens in every courtroom. The trial judge is the gatekeeper for evidentiary issues. The judge is ultimately responsible for assuring the due process is undertaken and carried out. I think in this particular case, it's very instructive that the court made a finding of fact, specifically made a finding of fact that Mr. Joyner was adequately represented both by an attorney and his Rule 17 GAL. They observe what goes on in the courtroom. They see, and as Judge Underwood did in this particular case, they see counsel sitting together with the Rule 17 guardian. They see them conferring with one another. And to the extent that they see that going on, then I think that they don't have any further responsibility. They have visual knowledge, they have firsthand knowledge. That's what happened here. And I think that in this particular case, this judge was convinced that Mr. Hedrick was working actively for Mr. Joyner.
Mr. Young, can I follow up on Justice Irvin's question about the different roles of the Rule 17 GAL and attorney, particularly in a situation like at the hearing in August when the father did not appear? What, if anything, is either the attorney or the GAL supposed to do at that point? And what, if anything, is the trial court to do?
Well,
if anything.
And it did happen in both cases, at both times in this termination series. I think in this case, the judge did exactly what was what they were supposed to do. They conducted the 7B1108.1 hearing, made sure there was adequate representation, made a determination in this particular case as to whether anybody else needed to be appointed. And in fact, a Rule 17 guardian was appointed to because Mr. Joyner had disappeared, he had shown questionable judgment. I think the proper procedure was to look into whether Rule 17 guardian was appropriate. This time the court made that inquiry and made that determination. And so that there was somebody in the courtroom who could assist counsel. And then likewise, I think that the responsibility was to make sure that as in some of these other cases, the attorneys were actively participating by virtue of their conduct. I think I think this court found that.
Well, what about in the hearing in August of 2019, when the father didn't appear on the second day of the hearing, and the GAL didn't say anything, and the judge didn't address the GAL? Should any of those parties that are the people, the GAL, the attorney, or the trial court have done anything at that point?
Justice, I believe Mr. Joyner wasn't there the second half of the first day. He was there, caught his ride, and disappeared the first day, and then definitely wasn't there the second day. I believe that what was done was appropriate by both the guardian as well as the trial court. The judge was adequately assured that somebody was there to assist the attorney, and that process did take place. They both sat together. They both conferred together. The first day there was objections. The fact that there weren't objections the second day, I think, is not really dispositive of anything. It could have been, and there's no way for us to really get into it, it could have been a strategy of trial counsel to allow Ms. Brotherton to take the lead. It's just something that we just really can't get to, and a court really can't ask that question, because it would be to breaching into work product and client confidences.
Well, what, if anything, should the GAL have done on that second day when Mr. Joyner wasn't there again?
The guardian ad litem's role then was to assist counsel, confer with counsel, and then if an adverse result was achieved, to try to vindicate Mr. Joyner's position by assisting with the appeal, which is exactly what he did.
I would just like to follow up on the question of what mechanism exists to determine if the guardian ad litem is carrying out their proper role. And is your position, based on what you said about the facts, what the facts show and what happened here, that as long as the guardian comes to court, then they have fulfilled their obligation, and there's no, because of the confidentiality protections, there's no way to inquire as to anything further?
Justice, I think there are certainly floors, and I think those have been set forth in the case law. In the ARC decision, the Court of Appeals found that where neither the attorney or the guardian ad litem said anything at all, I think that is certainly problematic. But that's not this case, and I think that there's certainly a floor on that level. What it is above that, I couldn't answer, but I think this particular case is an example where there was a happy medium. It wasn't the case that the guardian, like in ASY, where the guardian withdrew. It wasn't, the guardian stayed in throughout the case from start to finish. It wasn't the case like in ARC, where the guardian and the attorney remained silent. The guardian was objecting early on and assisted the attorney, who objected throughout the hearing in that particular case, in this particular case.
But here there was at least some indication that the father was not feeling that he was having communication, or at least I understood respondent's attorney to be arguing that the fact that he didn't know his name was an indicator of the lack of communication between the two of them. So there was something to put the trial court on notice that maybe the guardian had not engaged in the kind of counsel with the client that was needed.
Justice, I think there are many possible explanations. Also known to trial counsel was the fact, and evidence had already been turned over to defense counsel, that Mr. Joyner smoked enormous quantities of marijuana, and so that could have accounted for the fact that he didn't know Mr. Hedrick's name. So there's a myriad of explanations. I don't believe that appellant counsel is necessarily identifying something unique here. It could have been any reason why he didn't know that name.
Okay.
Where there is a guardian ad litem involved with an attorney to represent the interests of a responding parent, what should a trial court at a minimum do in order to protect the rights of that parent that has a guardian ad litem involved with him or her?
I believe that minimum, it's their obligation to be vigilant and assure that there is active engagement. The Rule 17 guardian should not be just sitting there looking off into space. They should be actively participating, whether it be verbal or in terms of communication with counsel. I think that's the bare minimum that a trial court should be looking at. If the GAL is staring out into space, not participating, not doing anything, then I think that may be a circumstance in which the trial court should intervene to make sure that all is well, and that the procedural due process of the parent is assured.
Well, how does the trial court have that represented on an otherwise cold record of appellate review such as this one? How does the trial court protect the record even when there's silence to show that the guardian ad litem may be recognized to be actively engaged by the trial court, such as huddling with the attorney, but yet that's not reflected on the record?
I think that it could be the case. They could make specific findings of fact, like in this particular case, the court could have said that counsel engaged with the respondent father before the hearing. Counsel actively communicated. The court could have done that, but I think I would get back to what was said earlier. There's a presumption of correctness that applies in these situations, that the judge is doing their job unless there evidence is out there to the contrary. And I think that in most circumstances, I don't know necessarily that they would have to go to those links and make those specific findings of fact.
What's your position on periodic check-ins, as Ms. Joyce suggests, could be at least an indicator that the trial court is keeping the GAL actively engaged on the record?
I think it would be an awkward thing to do in the course of the trial. Certainly unprecedented, something that we don't do now, and I don't know that it would make a whole lot of sense, because it would imply or suggest to the counsel and the Rule 17 GAL, hey, you're not doing your job, even if they really believe they would. I think that the statute provides for at 7B1108 that check-in, and I think that's adequate to make sure all of the substantive and procedural requirements are met. Once that's done, I think that the judges discharge their responsibility on a termination action.
Mr. Young, Rule 17 says the guardian ad litem shall file and serve such pleadings as may be required within the time specified by these rules. To your knowledge, is that the only tangible requirement of a guardian ad litem?
To my knowledge, that's the only tangible requirement. And then with respect to the case law, I think ASY may not even require that if you had an active client who was able to do that on their own. But that's the only tangible requirement that I'm aware of at this point in time.
Thank you.
Justices, if you have no further questions, I appreciate the questions you've asked, and I would yield to Ms. Kelly at this point.
Thank you very much. Good morning, Madam Chief Justice Beasley, Justice Newby, Justice Hudson, Justice Irvin, Justice Morgan, Justice Earls, and Justice Davis. May it please the court, I'm Elizabeth Kelly. I'm the guardian ad litem attorney advocate for the appellee minor children, Wesley and Natasha. It's a distinct pleasure to appear before this honorable court today. I want to try to respond to some of the questions, but I will just start by saying that we believe the issue before the court, the issue that Attorney Joyce briefed and asked in her reply that this court address, the issue of whether the trial court abused its discretion by proceeding to final judgment, because respondent father is alleging that the Rule 17 did not participate in the termination of parental rights proceeding. Therefore, he's contending that he was deprived of necessary representation that was ordered by the court at his counsel's request. We agree that the standard of review with regard to that issue would be an abuse of discretion standard. So the issue before this court would be whether the trial court's ruling is manifestly unsupported by reason or is so arbitrary that it could not have been the result of a reasoned decision. And I'm making reference to Justice Irvin's opinion in Ray TLH. The specific finding of fact that appellant referenced in the brief was finding of fact number 9. And finding of fact number 9 then bootstrapped into finding of fact 38 and 39, which appellant argues were ultimate findings. And if finding of fact number 9 is deficient, the court could not reach 38 and 39, which were the grounds for termination on the basis of neglect, as well as leaving the children in foster care for 12 months or longer without showing reasonable progress to the court in terms of a case plan. The very specific part of finding of fact number 9 that is complained of is the last part, that the father was appropriately represented by the Rule 17 GAL. The court also made the finding that he was appropriately represented by the attorney, but I would submit to this court that the very specific portion of finding 9 that's complained of is that he was appropriately represented by Rule 17 GAL. So on the standard of review of abuse of discretion, the question would be, is that finding so arbitrary that it could not have been the result of a reasoned decision, or that it was manifestly unsupported? Hearing the various questions of the court regarding whether the record was silent or cold on this issue, we disagree. We respectfully disagree. There was a question asked about different things that the court could do, and there was a pretrial hearing. There was a hearing on this trial that occurred in 2019 was a second termination of parental rights trial. The first TPR trial was vacated on behalf of respondent father because counsel was allowed to withdraw from the case. That did not happen here. So when the case came back before the court, the new attorney was appointed in late May of 2019, and a pretrial hearing was set, or a next date actually was set. It was actually set for the termination proceeding to begin, and that was June 14th. On that date, there was a pretrial hearing. On that date, counsel for father made request to the court for the appointment of a GAL. A hearing was conducted, father was present, and a GAL ultimately was conducted. While it would not be in the record, as fate would have it, Attorney Hedrick was actually present in court on that date on other matters. It was a regular scheduled court date for hearings. And so he was present. So he actually found out in real time that he was being appointed on this case. And there were records that were presented by subpoena to the court on that date. And he was even provided with a copy of records on that date. And those were the Daymark records. So that was the first instance where there was participation by the Rule 17 GAL. Then on that date, there was a continuance requested. It ultimately was set for hearing on July 25th of 2019. The father was present, the GAL was present, the attorney was present. They were present in the morning. There were discussions there were discussions at length in this case. And I think there was another question. I think Justice Morgan, you asked the question, what can a court do? Again, not reflected in the record other than the fact that you'll see some significant gaps in time if you look at the actual timestamps in the transcript between when the case was called and when hearings were had and how much time was spent actually hearing the case. And then there were recesses taken. There were conferences in chambers with Judge Underwood on every date that this case came before the court. Now, it would have been a better practice to have come back into court and, to the extent that was possible, note what happened in those chambers conferences. To some degree that did occur, but it's reflected in the record coming from the attorney for the father, not the GAL. And I would submit to this court that is because part of the reason for that is there was a question about 1101.1, I believe D, about the distinguishing roles of an attorney versus a Rule 17 GAL. The corollary to that is that the privilege also attaches because that Rule 17 GAL stands in the shoes of the ward. They also,
Ms. Kelly, I'm sorry. I hate to interrupt your argument, but it looks like Mr. Young has lost power, so we're going to see if we can get him back on.
okay, sure, thank you.
Apologize.
No problem.
Chief, asking him if he can connect maybe from his cell phone. I'm talking to him.
And so I was actually, Chief, I think we lost him at about the 6-minute mark. I saw him where he left. I did not want to interrupt. But it was about the 6-minute mark when he disappeared.
Thank you.
Do we still have you on the session?
Yes, I'm here.
Okay. Do you want to try to call Mr. Young via telephone? That
Okay.
looks like that's going to be the best way to get him, to just have him on the audio. And I'm not the host, so I don't think the system will read it.
Yeah, I mean, he's going to have to call in to the
Okay.
WebEx number and then enter in the access code.
Okay, I'll tell him. Okay, and we're working on getting him on by audio.
We all know that we're kind of grappling with the technology these days, so I hope everybody understands.
Absolutely. Thank you.
So I think he is now connected via audio. He's just in the attendee list because he's a call-in user. I cannot make him a panelist, so he will not show up in the grid. But we did get somebody who just joined in via phone, so I'm assuming that's him since that person wasn't there previously.
So can we confirm that he in fact hear what's happening? You're on mute.
Speaking of not being able to hear, thank you. I have sent him a text to see if he can hear us.
He just replied back to me saying that it's him and he can hear.
Okay.
So we can move forward.
Okay. Madam Clerk, take us back to the 6-minute mark. And Ms. Kelly, I don't know if you remember where 6 minute was for your argument. But if you recap as much as you possibly can, that would be
okay. Okay.
Thank you.
And Ms. Kelly, are you ready to proceed?
Yes, thank you.
All right, please go ahead.
Yes. So I think what I would focus back on is that we're discussing the finding of fact, the number 9 that sort of ties into the rest of the ultimate findings, and whether the GAL, whether the father was appropriately represented by a Rule 17 GAL. And I had gone through some of the instances that would support that participation. He was present and he participated. There's no dispute that he was present at all times, above and beyond, and that he participated. In fact, appellant's reply brief concedes that the GAL participated in the proceedings. The brief characterizes that participation as limited, but concedes that there was participation. And that characterization of limited participation. So essentially, the father is claiming that despite the fact that the GAL was appointed, a discretionary appointment at the request of his counsel, despite the fact that he was appointed, was present at all times at every proceeding, and he participated in the termination hearing. The father is essentially arguing that the GAL did not participate enough, and that thereby amounted to him not being assigned a GAL, and therefore that should be grounds for a new TPR. And there's a cite to In re Shepherd, which I would submit to this honorable court that case is very much different from this case. In that case, there was an issue presented to the appeal that the GAL breached his duties, or her duties, to her ward, because ultimately that GAL testified against that ward's interests. That GAL was called to the stand by the department, and also ultimately was called to the stand by counsel for that party. And that could have also happened in this case. Father complains that and says that his attorney indicated at that last hearing date on August 25th, the date that father did not appear, that she states that she needed him there to testify to certain things. Well, he stood in the shoes of the ward. He could have testified. She could have called him to testify, regardless of what that testimony might be. She could have called him to testify to the efforts that he made to work with the father to the extent that what he might be able to add to the proceeding would benefit him and seek to help secure a favorable verdict for him or judgment for him, or to the contrary. And that did not happen here. There was a question about whether ineffective assistance of counsel, if that's a standard that we're talking about in this case. And I did brief that a bit more in my brief, and understanding that the father's reply indicated that that was an analogous, I don't want to say argument, but an analogous reference that was made in the brief. Because there really isn't clear case law on the duty of the Rule 17 GAL in a hard fast rule, and so there was some reference to if there were deficiencies with the Rule 17 GAL, could it be analogous in some way to a lack of representation of an attorney? The father has conceded in the reply brief that there was nothing deficient in his attorney's performance. There were no issues there, nothing claimed there. And when you look at the case law regarding ineffective assistance of counsel, if we're looking at that as an analogous to be able to assist us in figuring out how we judge the duties and performance of a Rule 17 GAL, with respect to ineffective assistance of counsel, in re MZM, the court stated that the reviewing court really must indulge a strong presumption that the conduct falls within a wide range of professional assistance. And we would say that without a question, the Rule 17 GAL in this case met that. And in addition, it states that such claims are not meant to encourage judicial second guessing on questions of strategy and trial tactics. So by virtue of the fact that they sat at the same table, they sat and discussed the case, there were points at which, and that would reflect on the record, that the attorney Brotherton paused and said, "Your Honor, may I have a moment?" And she turned and conferred with counsel. They were slipping paper back and forth. The trial judge is the trier of fact in these cases. And so the trial court, the trial judge, Judge Underwood, had the opportunity to observe all of those things. And that then entered into her reasoning when she made the finding that he was appropriately represented by Rule 17 GAL. So
Ms. Kelly, when a parent is trying to make this argument that the representation by the guardian ad litem was deficient, is there a prejudice requirement?
I believe that prejudice does come into play because we're dealing with the totality of the circumstances and the fundamental fairness of the trial, because the attorney was not deficient and the GAL was active and participated. For there to be a remand for a new trial, there would need to be a showing of prejudice.
Thank you.
Thank you. And I see that I'm just about out of time. So I just want to say again, thank you very much for the opportunity to appear before this honorable court today. It has been a distinct pleasure. Thank you very much.
Thank you so much, Ms. Kelly. Ms. Joyce, did you have a few seconds left?
Yeah, can I just make a final sentence or two?
Sure.
Rule 17 has been interpreted by the Court of Appeals to require the presence and participation of the guardian. We urge this court to adopt that interpretation as well. We argue that there are critical stages or events that trigger a duty for the court to ensure that the guardian ad litem is acting as the guardian of respondents' rights. If a box checked that the guardian ad litem was present is enough, then the statute is just window dressing to give the appearance of fundamental fairness.
Ms. Joyce, assuming we hold that there is a prejudice requirement, do you contend that there was tangible prejudice in this case, and if so, how?
And I'm out of time, but I would say that, may I respond?
You may.
Okay, thank you. I don't agree that a prejudice requirement is appropriate in this circumstance, in part because of the same reason.
My question is, if we disagree with you, do you contend prejudice, and if so, how?
And I would say that because he was represented by counsel and the facts of the case were presented as well as counsel could, given his absence and given his lack of participation, then the prejudice is to the exercise of his due process rights and not to the factual determination of the case.
Thank you.
Thank you. Thank you so much to all counsel, Madam Clerk.
Oh yes, oh yes, oh yes. The Supreme Court of North Carolina will be in recess until the next calling of the calendar. God save the state and this honorable court.